Hi, my name is Rachel Okello and I'm a UK-based solicitor specialising in immigration, nationality and deportation law. And this is another video in the summer series of UK immigration videos on how to get people to come to the UK to live, work, study, join family or do business, people who need visas to come here. So foreign nationals wanting to have a holiday or create a new life in the United Kingdom. And today I'm going to talk about a deep topic really, because people have asked me to do videos on an amnesty. Whether there's an amnesty for people who are in the United Kingdom beyond the expiry of their visas or their residence card, people who are referred to as illegal migrants, illegal immigrants, overstayers, irregular migrants. I'm going to just say, for the purposes of this video, overstayers. Okay, so that means you've overstayed the time of your visa. And in fact, that's my area of expertise. I help people, particularly who are already in the United Kingdom, who have overstayed their visas or their residence card, their leave to remain, and they wish to reinstate their leave to remain and get themselves back on the correct track, looking towards getting indefinite leave to remain and permanent residence and possibly citizenship if they wish to become British. Some of the cases that we've done, I've had a case where we had a family and they were so frightened of being removed that they wouldn't come to the office. We had to go to them and meet them where they were and assess whether they had a case, because we don't take on any case before we begin a case. We assess whether somebody has good grounds to make a good case to the Home Office, which is likely to be successful. We can't guarantee success, but the Home Office rules are there, the Home Office, the immigration laws are there, the case law is there, the Home Office guidance, policy is there, and based on all of that we can assess whether somebody has good grounds to make an application to reinstate their leave to remain in the United Kingdom, and get a successful application either from the Home Office, or whether we're able to challenge it at court because we've assessed that it's a good case. So we will then challenge the Home Office for this family or other clients to see whether there is a case and a case to be made for the family to be granted leave to remain. So in this particular case, this family were granted leave to remain and are now living happily and legally in the United Kingdom. We've had another case which came to us in such a bad state that it took a while to unravel it all. We don't just throw applications in the Home Office. We get clients who say, oh, just put something in, put something in. We don't just put something in. We take time to put our client's case together, application and the supporting documents together, so that we can present the best possible case to the Home Office, and if necessary challenge it at court, where the judge can see, well, this case was correctly prepared, was rightly prepared, and leave to remain should be granted. So in this particular case it came to a deadlock really, where the client ended up in immigration detention and had removal directions for a flight which was at 5 o'clock on a Sunday morning. So midnight on the Sunday morning, we are still fighting this case on behalf of the client, liaising with the Home Office, trying to get them to back down, to say this person is, we've assessed it, this person is legally entitled to be in the United Kingdom. Home Office not backing down. Midnight on a Sunday morning, we call the judge. We call the judge and ask the judge to decide. 1 o'clock on a Sunday morning, still working, still at it, the judge gives us an injunction. Facts, everybody, the flight is cancelled. 5 o'clock on a Sunday morning, flight is cancelled, and we were able to get the client bailed out of immigration detention, and now that client has leave to remain and is legally in the United Kingdom, working towards getting indefinite leave to remain. On another case we had, the client came to us after many years of not knowing what to do with their case, and was removed, was put on a flight to their country of origin, but we kept going. Even though the flight had taken off, we kept fighting that person's case, and that client was brought back to the United Kingdom because we decided to continue to challenge the Home Office even though the plane had taken off and the client was brought back to the United Kingdom. And that's a case that we are still going to fight on behalf of that client. Okay, so if there's a case to be had, we are the people that will challenge the Home Office for you. Equally, if there isn't a case, then we will not challenge the case on your behalf. People sometimes come and say, but Rachel, I have the money. And I'm saying, that's great, but you need the money, obviously, for the Home Office fees and lawyers' fees, but you also need to have a case. So it doesn't matter who your solicitors, who your legal advisors are. You should be asking them, what Home Office rules, what case law, what laws are you applying in my case? Because UK immigration is quite clear cut. You know whether you're going to be able to apply inside the rules, and you even know whether you're going to be able to apply outside of the rules. It's quite a clear cut. The way that Home Office operate now, you're either in or you're out. It's not like the old days where we could say, oh, can you please exercise your discretion? The immigration rules of today are not based on asking the Home Office to exercise their discretion. They are quite clear cut. So let's now look at what are the grounds that people who don't have leave to remain in the United Kingdom can use to apply to stay here. Basically, you'll be looking at applying for your leave to remain based on your family or your private life in the United Kingdom. You won't be thinking, shall I apply to become a student if you've already overstayed? Or can I apply to work if you've already overstayed? For those type of applications, you'll be required to leave the United Kingdom and apply to re-enter. And obviously there'll be a struggle there because you've already overstayed. So we're looking particularly at private and family life applications for people who've overstayed but wish to remain in the United Kingdom. Many people come to us, and I read it all the time in the papers, somebody saying that they've been here 15, 16, 17 years and they've done everything that the Home Office has asked them to do. They've done, they've been reporting, they've been working, they've been doing everything a good citizen would do. Unfortunately, the basis of their residence in the United Kingdom is unlawful. So the Home Office and the courts and Parliament, what they say now is that you cannot rely on your illegal residence in the United Kingdom as a reason why you should be allowed to stay here. So if you've been here for less than 20 years, because the new rules require you to be here for 20 years at least, if you've been here for less than 20 years, then it is going to be exceedingly difficult for you to rely on your long residence to be able to stay in the United Kingdom. You are required to be here continuously for at least 20 years, and then you have to prove that you've been here for 20 years before the Home Office will give you leave to remain. And then they will put you on the 10-year route to settlement. So you effectively would have to have been here for 30 years before you get indefinite leave to remain. Because that 10-year route, which has been in place for many years, which says that if you've been here legally for at least 10 years, then you can get indefinite leave to remain. So what the Home Office is pushing everyone towards now is the 10-year route to settlement, so that once you've been here for 10 years, lawfully, you can get indefinite leave to remain. Okay, so you'll be looking at, if you're over 25, you'll need to have been here for 20 years, at least, continuously, and be able to show that that's how long you've been here before the Home Office will give you leave to remain. Okay, if you are under 25 and you wish to stay in the United Kingdom, you're over 18 and under 25, so you're 24, you're not 25, then you can apply to stay in the United Kingdom if you have been here for half of your life. So if you are 24 and you've been here since you were 12 for 12 years, then you can apply to stay in the United Kingdom on that basis, on the basis of the fact that you've been here for at least half of your life. And again, you'd need to show documentary evidence to prove that you've been here. And once you've proved that, then the Home Office grants you your residence card quite easily. And you'll be then put again back onto that 10-year route to settlement. So you need to have 10 years continuous lawful residence before you can get indefinite leave to remain. And once you have got indefinite leave to remain, then you're no longer subject to immigration control, you no longer have to make any further applications, and you can even look towards becoming British if you wish to do so. For people who are under the age of 18, the Home Office will want to know whether the child, so your child, has been here for 7 years continuously. And if they have, then they become a qualifying child. So it'd be one of two things. It'll either be a British child or a child who's been here for 7 years continuously, and they'll be called qualifying children. So they can, the family, because if you're British, you won't need to make an application, but if you're a parent of a British child, looking to rely on that child then you can make an application based on your British child, because that child is a qualifying child, and that qualifies you to make an application for your own leave to remain as a parent, okay? Because you are a parent of a British child. If you are a child who has been living in the United Kingdom for at least 7 years, but you don't have papers because you came with your parents who never had papers, or you're born here and your parents didn't have papers, so you're born in the United Kingdom, although you've been here all your life, you don't actually have papers to be here. You will have to wait until if you're born here, until you get to age 10, and then you can register as a British citizen, or at least if you are age 7, you can apply to stay in the United Kingdom because you'll be a qualifying child. And if that child is successful in being able to prove to the Home Office that they can stay here, because it's unreasonable to go back to their country of origin, if the child is able to show that, then it will follow that the parents and any other siblings who are in the same family unit as that child will also be able to get residence in the United Kingdom. Okay, so there's the 20-year rule for people over 25. If you're between 18 and 24, then you need to have been here half your life. If you're under 18, then you need to have been here at least 7 years continuously, and show that it's unreasonable for you to return to your country of origin. And if you're a parent with a British child, then you can apply to stay here on that basis, and that application can be made under UK law, which to me is a stronger application to make, or you can make that application under European law, which if you apply under European law, you won't actually qualify for indefinite leave to remain. You're only qualified to stay in the United Kingdom as a parent of a British child whilst that child is a child. Your time here definitely depends on the child being in the United Kingdom, as opposed to if you go on the UK route and you're working towards your own indefinite leave to remain, because you're also on that 10-year route to settlement. Okay, so that's just a snapshot of how people who don't have their leave to remain in the United Kingdom can obtain leave to remain in the United Kingdom if you've been here as an overstayer. It's not easy, but it is definitely possible. So if you want to discuss this specifically in your personal circumstances, then you can call us on 01213 894 895, or you can contact us via our website, and you can book your free assessment from the website at clarityvisas.co.uk. And we're based in Birmingham, but we have clients, as you can imagine, as immigration, so we've got clients from all over the UK, all over the world. Okay, so contact us for your immigration needs, not just on the issue of overstaying, but any other immigration issue that you wish to be advised on or get representation on. Then do contact us, clarityvisas.co.uk. Continue to follow our Facebook page, Rogel's Immigration Experts, and have a great day. It's wonderful weather in the UK at this time of the year, and keep the faith. Thank you. Bye bye.